Okay, get this. A group of top secret intelligence officers, the very people who were supposed to protect the nation's secrets, decide to sue their own government. I know, it sounds like something out of a spy thriller, but this actually happened, and it sparked one of the biggest legal showdowns in modern British history. So let's dive into how these spies took on the state and ended up changing the law forever.
Really, this whole incredible story boils down to one single question. We like to think that our governments have to follow the rules, right? But what happens when a government says, actually, we have a special kind of power that puts us completely beyond the reach of the courts? Well, that's not just a debate for a classroom. It was the heart of a real-life David versus Goliath battle.
All right, so our story kicks off at a place called GCHQ. That stands for Government Communications Headquarters. You can think of it as Britain's version of the NSA. It's this huge, super-secretive agency that handles signals intelligence. But the people working there, they were just regular civil servants. And like a lot of public sector workers, many of them were members of trade unions.
Then, boom. On January 25th, 1984, everything gets turned upside down. With absolutely no warning, no discussion, the government just announces a ban on all union membership at GCHQ. The staff got a pretty brutal choice. Quit your union and we'll give you £1,000, or you're out of a job. The government's line was that this was all for national security, but to the unions, this felt like a massive, unprecedented attack on their fundamental rights.
Now, you might be wondering, how on earth could the government just do that? Didn't they need to pass a new law in Parliament? Well, their answer was basically, nope. They claimed they were using a very special, very old type of authority. Think of it as a kind of political superpower that's been around for hundreds of years.
And that power is called the royal prerogative. It's basically a collection of powers that used to belong to the king or queen directly, but are now used by government ministers. We're talking about big things, like deploying the army or signing international treaties, all without needing a specific vote in Parliament. It's a power that flows directly from the crown, not from our elected representatives.
And here is the absolute key to this whole thing. Power that comes from a law passed by Parliament, the courts can almost always look at that. They can review it, challenge it, interpret it. But for centuries, the royal prerogative was seen as totally different. It was a judicial no-go zone. So the government's argument was pretty simple. We used a prerogative power. The courts can't touch it. Case closed.
But you know what? It wasn't case closed. The unions weren't going down without a fight. And they decided to use a really powerful legal tool, one that's specifically designed for holding public bodies accountable for their actions. They took the government to court for a judicial review. Now, it's really important to get what this is. A judicial review isn't about a judge saying, I think that was a bad decision. It's about a judge checking if the decision was made legally and fairly. Did the government follow the right process? Were they acting within the law? That's what was at stake.
So this set the stage for a single explosive question. For the very first time, the courts were being asked to apply judicial review to the royal prerogative itself. Was this ancient, seemingly untouchable power finally going to be held to the same standards as everything else? The case went all the way to the top, to what was then the UK's highest court, the House of Lords.
I mean, you can imagine, the entire legal world was watching. This wasn't just about spies and their unions anymore. No, this was about the fundamental balance of power between the government and the courts in the UK. And the verdict, well, the verdict was going to change everything.
And what the court decided was nothing short of revolutionary. In this huge landmark ruling, the judges basically said, you know what, we don't care where the power comes from. It doesn't matter if it's a brand new law from Parliament or some ancient power from the Crown. What matters is the nature of that power and how it affects citizens.
One of the senior judges, Lord Diplock, said it perfectly. From now on, he said, government action is subject to judicial review no matter where it comes from. And just like that, with those words, centuries of legal tradition were swept away. The royal prerogative was no longer above the law.
So, the unions won. A huge victory, right? Well, this is where the story takes a really fascinating and kind of complex turn, because they had just won this massive, history-making victory for the rule of law. But in a stunning twist, they actually lost their case.
Okay, so here's how it went down. The unions argued that since the government had always consulted them before on major issues, they had what's called a legitimate expectation that they'd be consulted this time too. And you know what? The court agreed. They said, yep, ordinarily you would be right. The government acted unfairly by not talking to you. However, and this is the big twist, the court then decided that the government's duty to protect national security was just so vital that it overrode the duty to be fair. In their view, the security risk trumped the procedural unfairness. So you end up with this incredible split decision. On the one hand, a massive, game-changing principle was established. No government power, not even the royal prerogative, is immune from the courts, a huge win for accountability. But, on the other hand, the actual spies who brought the case lost. The Union ban at GCHQ was allowed to stay. They won the war, but lost the battle.
So why are we still talking about a legal case from the 1980s? Well, because its shockwaves are still being felt. It completely redrew the map for the relationship between the government, the law, and the rights of ordinary people in the UK.
The legacy of the GCHQ case is just immense. First, it cemented the idea that even the government's superpowers have to answer to the law. Second, it blew the doors wide open for judicial review to be used in all sorts of new challenges against the government. But it also created this powerful precedent. When a government says this is about national security, the courts are going to be very, very hesitant to step in. It's a delicate balancing act that's still being navigated in courtrooms to this day.
And that really leaves us with a question that's as relevant today as it was back then. The GCHQ case drew a new line in the sand between the power of the government and the authority of the courts. But every single time an issue of national security comes up, we're still fiercely debating where exactly that line should be drawn and who ultimately should get the final say.